A common concern among affirmative action opponents, which includes employers and politicians, revolves around the terming of related programs as goals and timetables was a proxy to enforce quotas. The United States Civil Service Commission sought to clarify the issues raised with the alleged push for quotas in 1969. A goal is a realistic objective which an agency endeavors to achieve on a timely basis within the context of the merit system of employment. A quota, on the other hand, would restrict employment or development opportunities to members of particular groups by establishing a required number or proportionate representation which agency managers are obliged to attain without regard to merit system requirements. Quotas are incompatible with merit principles. While fixed quotas seem to be outlawed in affirmative actions involved in employment, university admissions have minority quotas. The Supreme Court recognized the need for diversification in two contexts. First, the court ruled that student body diversity in higher education is a compelling government interest since it breaks down racial stereotypes. The court also recognized that prioritizing minority-owned businesses in licensing broadcasting stations raises the voices of the minority in society. Justice O'Connor, who concluded the Supreme Court in Grutter, used briefs submitted by Fortune 500 companies on the importance of diversity and skill development. According to the court, diversity promotes cross-racial understanding, helps to break down racial stereotypes, and enables students to better understand persons of different races. The court recognized the difficulty of justifying gender-based affirmative action since the whole idea of racial minorities and non-minorities interacting with each other is not applicable to gender because brothers have sisters, fathers have mothers and daughters, and husbands have wives. Gender-based affirmative action in spheres such as education needs altering recruitment patterns and eliminating institutional practices that limit or discourage female participation, as opposed to DeFunis-type special admissions programs. The antithesis of Brown v. Board of Education represents the movement championing for sex-segregated education in elementary and secondary public schools. The resulting debate revolves around whether sex-segregated public education produces positive results or adds to the harmful stereotypes. The argument on racial diversity breaking down stereotypes and bias is thought to be the same with gender diversity, with women's presence in traditionally perceived male-dominated spaces such as leadership being portrayed as having the ability to demolish stereotypes of incompetence or lack of interest. Increasing the number of women in leadership positions is deemed as suitable in promoting acceptance, tolerance, and mutual respect, of course with the mutual respect part being quite questionable considering the attitudes held by middle to upper-class working women towards men. For instance, an increase in the number of female lawyers has managed to challenge the Supreme Court stance in 1873 that the natural and proper timidity and delicacy which belongs to the female sex unfits it for legal practice. Some studies document the importance of having female voices in corporate boards and politics where significant decision-making processes take place. The studies find that gender differences are valuable in corporate governance by adding a range of life experiences that raise the quality of discussions. According to sociologists, women's communication and decision-making differs from men's in ways that are beneficial to complex environments. Women are perceived to be more self-sacrificing than men as they are willing to support women's issues compared to men. All the arguments surrounding gender-based affirmative action revolve around the fact that men and women are different, which raises concerns around conservative backlash. Sonia Sotomayor was scolded in her 2001 nomination proceedings in which she commented that a wise Latina woman with her experience might have better legal conclusions than a white male, effectively suggesting that minority judges perceive cases differently. Judges do bring their life experiences into hearings, including those unique to their gender. Sociologists argue that these differences in experiences do not make female judges, politicians, or corporate board members more sympathetic to gender concerns, but they supposedly have a better understanding of the issues being raised. In 2004, Norway instituted quotas to integrate women into corporate leadership through the corporate board quota that required all publicly listed companies to have a minimum of 40% of either gender, of course meaning women, on their boards or otherwise face the penalty of being dissolved. The European Community's Amsterdam Treaty of 1997 endorsed gender-based affirmative action, arguing, quote, with a view to ensuring full equality in practice between men and women in working life. The principle of equal treatment shall not prevent any member state from maintaining or adopting measures providing for specific advantages in order to make it easier for the underrepresented sex to pursue a vocational activity, or to prevent or compensate for disadvantages in professional careers. The amendment sought to clarify the separation of affirmative action programs from EU gender anti-discrimination provisions. In other words, the EU gender anti-discrimination provisions were perceived as not enough in the pursuit of equality that new guidelines were required. The treaty focuses on removing obstacles, especially stereotypes that disadvantage women when seeking employment, enable the ending of gender underrepresentation in certain fields. In 2011, India launched the radical political experiment that reserved 1/3 of seats in village governing bodies to women, since a study uncovered that female village leaders were more likely to invest public resources into community projects surrounding women's concerns such as health and education. Other studies have documented the fact that female presidents lead differently from their male counterparts, as they're more attentive to issues that they deem to affect women more, such as poverty, war, and maternal mortality. The 1995 United Nations Fourth World Conference on Women in Beijing witnessed governments adopting the Beijing Declaration and Platform for Action that specified a minimum quota of 30% for women in decision-making positions. As of the 2010s, more than 100 countries had passed measures to promote women's political representation, including quotas at the political party and subnational levels, constitutional amendments, and national election laws. The Portuguese parliament passed a gender quota law in 2006 that requires each party listed for any election to have at least 33% of the members being women. France passed the parity law in 2000 that required parties to present lists of candidates with 50-50 gender representation. As a result, women obtained near parity in all positions, and the hope was that more women would be running for public office, especially higher offices. The 2003 Rwandan constitution mandates quotas to ensure women's representation in the national parliament has witnessed a higher number of women being elected into office, constituting upwards of 48% in parliament. Iraq's constitution requires that 25% of National Assembly members be women, a phenomenon that witnessed 82 women being elected. Political affirmative action is unheard of in America, with women's political representation being below the 30% Beijing requirement. The U.S. ranked 73rd in the world in terms of female representation in politics as of 2011, up from 85th in 2008. Women constituted 16.8% of the 11th Congress and 24.3% of the state legislatures. 17.5% of U.S. cities with over 30,000 people had female mayors in 2009. It is evident that a lot of countries have sought to increase female voices in business, politics, and academia through quotas. The American courts prioritized race-based affirmative action, while the European Union focused on economic agreements against equal pay discrimination. The European Court of Justice suggests that affirmative action attains a legitimate objective using proportional means. Title IX, which was established to end discrimination in vocational institutions, is lauded as one of the greatest examples of what affirmative action could do. The underlying regulations state that in the absence of a finding of discrimination on the basis of sex in an education program or activity, a recipient may take affirmative action to overcome the effects of the conditions which resulted in limited participation therein by persons of a particular sex. Today, there are more girls than boys in school and more women than men graduating college. The discrimination that supposedly led to more boys than girls in school was termed as unfair, while the discrimination that gave us more women than men graduating college is somehow labeled positive. Even with the whole Title XI opening doors and creating opportunities for women, studies show that the number of female coaches heading male teams has stagnated at less than 3%. 68% of head coaching jobs for female teams are occupied by men, and the number of sport programs headed by women have been on the decline since 1972, when departments were merged, which witnessed women being demoted to assistant and associate directors. When affirmative action only covered racial differences, feminists questioned why courts and society tolerated discrimination against women to a greater extent than they did race. Some feminists suggested that analyzing gender preferences is more important because of the subtle and elusive nature of sex discrimination. Feminists suggested that differentiating physical variations from paternalistic classifications that stereotype women requires greater scrutiny of gender-based affirmative action. The Supreme Court's analysis of gender preferences is clearly outlined in two fundamental cases. In Mississippi University for Women v. Hogan, a male nurse attempted to apply for enrollment in the all-female Mississippi University for Women, which the university declined, arguing that the essence of the school being all-female was to remedy past discrimination. The court ruled that all-female schools were based on the stereotypical presentation of male and female roles, thereby making it unconstitutional. The enrollment process based on gender assumed that only women have nurturing abilities that qualify them to become nurses. The court, however, believed that gender-based affirmative action is truly justified. In limited circumstances, a gender-based classification favoring one sex can be justified if it intentionally and directly assists members of the sex that is disproportionately burdened. In United States v. Virginia, Justice Ginsburg argued only an exceedingly persuasive justification validates gender bias, thereby making the exclusively male-only policy in Virginia Military Institute unconstitutional. She reiterated that women's advancement and equal participation in employment and education is a necessary justification for bias. Sex classifications therefore seek to compensate women for economic disabilities. However, the relevant stakeholders should be careful in distinguishing between valid justifications and those that create or perpetuate the legal, social, and economic inferiority of women. The Supreme Court of the United States of America has never addressed the constitutionality of affirmative action in the workplace except through Title VII that does not differentiate gender and race discrimination. Congressman Howard Smith, who strongly opposed civil rights legislation, suggested the addition of gender-based discrimination. The Sixth and Federal Circuit Courts strictly scrutinize race and gender-based affirmative actions. The Sixth Circuit, unlike the Supreme Court in Johnson, did not recognize the underrepresentation of women in business as an outcome of gender stereotyping of women as incompetent. Gender and race-based affirmative actions are unconstitutional in states like Michigan, a phenomenon that was noted in 2002 at the national level where the Federal Circuit suggested the strict scrutiny of gender and race-based affirmative actions in the U.S. Air Force. The 3rd, 5th, 9th, 10th, and 11th Circuits have rejected the scrutiny of gender-based affirmative action programs. For example, the 9th Circuit invoked Califano v. Webster, where the court addressed a challenge to a Social Security provision, in effect from 1956 to 1972, under which female wage earners, for purposes of calculating retirement benefits, could exclude from the computation of their average monthly wage 3 more lower-earning years than a male wage earner to compensate women for their economic disadvantage, in deciding that reducing male and female economic disparities caused by discrimination against women is an important government objective to justify preferential treatment. This phenomenon has been supported by the 10th and 11th Circuits, evidencing that affirmative action may be upheld even in lacking proof that the government discriminates against women. Various arguments have been fronted against affirmative action and its use as an approach to achieving equality or whatever it is. Ruth Bader Ginsburg and second-wave feminists constantly attacked affirmative action, arguing that the alleged benefits directed towards women do not match the fact that laws, policies, and programs present women as weaker, needier, and less competent. Justice Ginsburg argues that she remains suspicious about protective labor laws that seek to protect women since they prevent them from securing higher-paid work. Some studies suggest that gender-based affirmative action is a source of hostility, especially sexual harassment in the workplace. The studies trace back workplace sexual harassment to affirmative action programs that mandated women to be allowed into male-dominated spaces. By the 80s, at least 30% of women who had entered male-dominated blue-collar spaces reported harassment, with the percentage being reportedly higher when accounting for those who suffer silently, as noted by feminists. The said males feel like they're losing their positions to women, especially women who they perceive as less qualified and have only gotten their positions due to affirmative action. This phenomenon leads to a wide range of negative emotions, including anger and resentment. There's also the argument that affirmative action programs and policies cause friction between husband and wives, as well as brothers and sisters. As it pertains to women being awarded positions without merit but purely based on gender, put a pin on that one. There's a widespread belief that the gains that have been made by women over the past few decades have made affirmative action unnecessary. The attitudes surrounding this argument depend on who you ask, with feminists believing that women have a long way to go to eliminate the barriers against women, while egalitarians believe that the barriers against women are long gone. The discussion of the barriers facing women in everyday life goes something like this.
Yes! God, it's so good. I was watching her face. She was just like waiting for that moment. This is so great. I love it.
I don't.
For you to have a bunch of ramps in your life, it doesn't do shit. I need those ramps, right?
Can we stick to male versus female?
The conversation is not about disability. If you want to have a debate about being a disabled woman or just a disabled person in the workplace, that is an absolutely valid conversation to have, and we should have that conversation so that you are able to have the same opportunities as everybody else, because physically, even if you want to do a job, there might be ways, that we need to rework things for you. We're not talking about that here. This is a debate about feminism, but because everybody has decided that feminism is also for disabled people and also is a thing about racism, and we also have to talk about trans people when it comes to feminism, all of that stuff. No, we are literally just talking about males and females. It really should. We have to talk about the difference of premises. So Eli was talking about equity versus equality and was saying we don't want to have sameness, we want to have fairness. I don't operate based on the principle of everything being fair. Life is not fair. It will never be fair. Many circumstances that I had growing up in my life, they were not objectively fair, but I grew from them. I moved on. I learned. There are obviously people that dealt with more than I did, continue to. That's not fair, but most of them learn how to work through that, become empowered, move on. That is how you survive in this world. That is why you can't just go around hoping to find happiness, because like eternal happiness doesn't really exist. You have to find a way to be fulfilled and to constantly be overcoming challenges. That is how the world works. Just saying I want fairness. That doesn't exist. That's not realistic. So when you're looking around at the world around you and you're going, why am I so different from these people? I just don't understand. It's because they're operating from totally different premises than you. And it's okay to admit that. And it's freeing, but it also was kind of upsetting because it's like, okay, there's no way that we could ever really like find significant common ground, because from like a value standpoint, we just wholly disagree. Like we will never find common ground on that point, because I don't believe that fairness is attainable or even needed. Life isn't fair to begin with.
Second-wave feminists argue that due to the successes of the feminist movement, young women do not recognize the existence of pay inequity and glass ceilings, as well as the fact that gender still restricts opportunities. I'm sure they mean for women. This phenomenon could not explicitly be tied to a generational gap, and statistics have shown that majority of women, both young and old, have supported recent initiatives that have banned gender and race-based affirmative actions. 58% of white women supported California's Proposition 209 that outlawed gender and racial preferences in the state. Washington enacted an analogous initiative despite efforts of the National Organization for Women to inform women of the need for affirmative action. In 2004, Michigan's women's groups campaigned for affirmative action, arguing, "Women are the most frequent beneficiaries of and will lose most if affirmative action is lost." However, the efforts of the women's groups did not stop women from voting for the Michigan Civil Rights Initiative that banned any form of affirmative action in Michigan education, contracting, and public employment. The unnecessary perception of affirmative action is also supported by the fact that its intended outcomes could be achieved by fair, otherwise neutral laws. The Supreme Court in 1979 argued, quote, "where the state's compensatory and ameliorative purposes are as well served by a gender-neutral classification as one that gender classifies and therefore carries with it the baggage of sexual stereotypes, the state cannot be permitted to classify on the basis of sex." Many feminists believe that the obstacles perceived to prevent women from advancing in the workplace could be eliminated by gender-neutral laws, including those that mandate childcare, prohibiting discrimination against those who take time out for unpaid care work, promoting minimum wage, and flex time arrangements. The Family and Medical Leave Act, FMLA, that requires employers of 50 or more employees to provide up to 12 weeks unpaid but job-protected leave to male and female employees who parent newborns or adopted children or those who need to take care of loved ones in serious conditions. The act sought to create equal employment opportunities for both men and women by balancing workforce demands with families' needs. The act is written in gender-neutral terms in recognition that stereotypes regarding families affect men and women negatively, especially considering the fact that parental leave is only provided for women in instances where men have it. The duration is significantly shorter than that of women. The efficacy of affirmative action has been questioned over the recent past, with there being claims that women have benefited more from related laws and policies compared to racial minorities. However, some commentators suggest that it is difficult to point out the differences that have been made due to affirmative action with exact precision. It is undeniable that affirmative action has opened doors for a lot of women in various fields they're interested in, with this interest being exclusively based on money and power.
Selective equality is so true, because we are only equal until we don't want to be equal anymore. We always want more female CEOs, but nobody wants more female plumbers. You know, it's the men who go to war first. It's the men who are building the very infrastructure which we walk on. You know, I was walking on Brickell Quay the other day and I saw these men hanging from these cranes. They're putting these windows on, and I saw one man trying to like hang out the window to grab the window, and it's the men that are doing that. It's not the women. Men create the infrastructure that the boss bitch can then sit out on and go, "I'm a boss bitch." But who put you there? It was the man. The man created the chair, the floor, the levels. It's the man that's going to run into the burning building. You're going to call the men when somebody comes and robs your house.